Today we will have an interesting discussion on joint ventures. When we talk about joint ventures, we can think about two separate aspects. One is an incorporated joint venture and one unincorporated joint venture, right? So we will try to sort of deal with both aspects of this, during the course of our discussion. But before we get into that, sort of initial thoughts. Over last 2 decades, I have had a chance to work both on incorporated and unincorporated joint ventures. I have seen how parties negotiate, how parties decide their business plan, how parties, draft contracts, how parties, sort of behave during the course of negotiation, and how parties end up splitting as joint venture partners, exits, or even joint venture disputes and arbitration for that matter. So, having seen this very, very interesting journey over a period of time, we thought we will share our experiences on various facets. If you ask me, we can write a book actually on joint ventures, right? Because that's a very, very fascinating subject overall. But insofar as the need of the joint venture, I thought I'll just quickly talk about few points before we actually get into each and every element of joint venture. Traditionally, if you see in the Indian context, before we opened up, as the economy or the as a regime, what used to happen is because a foreign investor could not really come directly and set shop, they always needed a partner in India. So there was a legal need, previously. Thereafter, even after opening up, some sectors retained FDI control. For example, telecom, broadcasting, insurance. So all these sectors could not have foreign entities setting up 100% subsidiary and start businesses. So obviously there was a requirement to have a local partner. So there is a legal need, as I said. But beyond legal need, you will find that parties would still want to have a joint venture for other reasons. For example, some party may have a very good technology which they want to sort of manufacture and sell the products in India, but they don't have local know-how, local sort of understanding of manufacturing issues or labor issues and the like. So more from a business perspective, they would want to come and partner with an Indian entity. So the reasons could be multiple, but the short point remains that when we talk about joint ventures, the concept essentially is that both parties are trying to bring some specific aspect to the table and are not merely financial partners. When you talk about financial investments, the construct of the relationship, the construct of the deal may be different. But when each party brings some strength to the business, whether it is brand, whether it is technology, whether it is manufacturing capabilities, whether it is local know-how, all these aspects together, when both parties bring to the table, that is when we can say, a joint venture gets created. So with that brief background, I think I'll move first to Vaibhav, whether you call a, an incorporated joint venture or a incorporated joint venture, what are the initial elements that parties typically look out when, they are at least conceptualizing, the joint venture, commercial aspects, structuring aspects. Just if you can, sort of throw some light on those aspects, Vaibhav.
Thank you, Gowree. No, I think what you said makes sense, and I'm just taking forward what you said, right? Whenever someone comes to us saying that they want to do a joint venture, right, the first important aspect is to understand why, right? Why they want to do a joint venture, because unless you understand the objective of the joint venture, you're not going to get it right, right? So we try to see, do you really want to set up a company, right? As Gowree mentioned, right, you can have a contractual joint venture. It's not necessary that you need to set up a company and fund it, right? Both joint venture partners may have their own company. They may be in India, they may be outside India. If there is no requirement to set up a company in India, then you may want to do it as a just an agreement. This agreement can be more of a licensing agreement, distributor agreement, some kind of agreement which can suffice, rather than requiring a third company to come into picture, which will then work along with the other two companies. So there have been several situations where we have said, you may want to rethink whether you want to set up a company and just enter into a joint venture agreement, which is contractual. Of course, entering into contractual joint ventures may have different tax aspect, and maybe we'll cover that later. But from business perspective, from concept perspective, that's the first thing you do. If you decide that there is no need to set up a company, then need to identify what are the different agreements I need to give effect to the same to the objective, right? I remember there was a client who came and said we want to set up a company, a joint venture with someone in India, and that company was based in US. And then the issue really was that if they set up a company, what will that company do? All they wanted to do was sell their product or technology, what they were doing, what they were preparing in US. They wanted to do it in India. They want to sell that in India, and they didn't want that joint venture company to manufacture. If the joint venture company did not manufacture, then what exactly they will do? So that's where we told them that you may want to look at the contractual joint venture. So that is a option which you should look at it. Second is if you decide that you want to set up a joint venture company, because as Gowree said, there are two parties who are bringing two different things, and then the joint venture company will actually manufacture or create something independent, right? Then you say, okay, fine, we will set up a joint venture company. But question is, should it be a company? Should it be an LLP, or should it be some other entity? So choice of entity becomes important. About most of them do settle as company, but in my view, you need to look at it based on the objective. Whether you should do it as an LLP or as a company. LLP has certain advantages and certain disadvantages, and the same thing is there with the company. Now, LLP, you have less, it's less regulated. You can actually form your own clauses in your charter documents. You may not have certain rights which you have in a company. You may not have in an LLP, so you need to be extra careful in the documentation. Also, the taxation is very different in the way companies tax and LLPs taxed. So that's the other aspect which you need to keep in mind. And what you need to keep in mind is that tax laws can change, just like how it changed recently, where dividend distribution tax became dividend tax, right? So when they change, the structure you choose should not be adversely affected, right? So you need to be a little careful of why you are setting it up, a LLP or a company. With that, then you first go with the kind of a term sheet where you identify, as Gowree says, what is the objective, what everybody is bringing to the table. And once you identify what everybody is bringing to the table, then you identify what are different documents we need to capture those elements, right? So, for example, if one person is bringing IP, then you need an IP agreement, right? If one person is bringing capital, then that will be taken care in the joint venture agreement, right? If somebody is bringing local know-how or a management capability, then you need to make sure that that is captured in the agreement. So the objective which you are entering, what is expected from each other, is captured in the agreement, right? So that is something which you need to capture in your term sheet, right? What are different documents you require? It may be a joint venture agreement, it may be a distributor agreement, it may be licensing agreement. So different kinds of agreements will be there. Employment agreement. So you need to be making sure that you capture all different kinds of agreements in the term sheet. The second thing is also important is to say what kind of joint venture it is. Is it a 50-50 joint venture? Is it a 51-49 joint venture? Or it is different joint venture, 70-20, 70-30, 80-20, right? It really depends on, again, how they are looking at the future. I remember very long ago when I started my career, I read a McKinsey article which says that the most successful joint venture is 50-50 joint venture. It was a Harvard Business Review article, and they did studies, various. It says when both partners are equal, that joint venture seems to last the most, right? So that is something you need to keep in mind. But a lot of time client says I want 51-49, and often that may be a recipe where the joint venture will not last long because there is inequality in the partnership. But if that is what is required, then that is what is required. So that is a key aspect. You look from when you take the decision of what percentage you are looking at, you look from how long you want the joint venture to last. Most of the time people come with an idea that this will last forever, but history says that most joint venture do get wound up at some point in time, irrespective of whichever joint ventures, whichever field they are, right? Once the objective get kind of resolved or objective becomes irrelevant, invariably they will wind up. So you need to plan for that. How long do you want your joint venture to last? If your joint venture is going to be lasting a short few years, right, as opposed to many few decades, right? You have a very different thought process you will put it in, right? And I'm talking about intentional termination, intentional life of a joint venture, and not because of the dispute. That's a very different aspect. uh, but that is the other thing you need to keep in mind, because if you are going to say, okay, it's going to last just 3 to 4 years, then you need, how you're going to fund it, how you're going to staff it becomes very different. And once the termination happens, then who is going to take what, right? That is again a point which you may want to discuss and cover in the documentation. uh, Often when it comes to agreements, key aspects is funding. You want to make sure who is going to fund. Again, depending on the objective, how the funding goes, and is one party going to fund, or is both parties likely to fund? How are the revenue streams going to come up, right? For example, will there be a revenue only by the joint venture company, the new company which you have created? Will the revenue be distributed immediately, or will it actually remain in the joint venture company? Will there be any licensing fees which both companies will pick it up? Uh, we have seen a situation where somebody has not just said, I will take participate in the revenue of the joint venture company, but I also want certain percentage as my license fees because they are bringing technology to the table. Then the other joint venture partner may say that, look, I'm bringing management to the table, so I want salary or a compensation or a bonus, which is consumer. So you need to figure out that as a part of your term sheet, right? And documentation. So these are important aspects, commercial aspects, which needs to be taken care of at the start of the relationship. Uh, once you kind of decide on that particular perspective, keep in mind that there are Indian laws with respect to what a 50-50 joint ventures, and maybe we'll discuss this in detail later on. But how many board members each party appoint, and what kind of casting voting rights, if it is a 50-50 JV or not, or whether it is if it is, let's say, 51-49, then how it is likely to work in terms of votings, right? So that needs to be determined in the term sheet. So that's a critical aspect. uh, Once the term sheet is done, typically, and it's assuming the new company is incorporated, there may not be a diligence required in this, but getting into the documentation, getting into nitty-gritty, we always keep in mind that clarity reduces dispute substantially. So getting into detailed documentation, even though your relationship with the joint venture partner is great, discussing threadbare, going in detail, and making document clear so that 5 years down the line, the people who negotiated may not be there, and they may not have the context of the agreement. But when 5 years down the line someone reads it, they can clearly see what was intention of the parties at that point in time, and how they how they, kind of wanted to run, right? So it's very clear. Documentation becomes very, very important. A lot of times we see that people say, okay, we don't have a solution today. We actually will, decide later on how to run certain things, right? And we always say that, look, if it's a short term, it is fine because your relationship is good. But if this is going to have a long term impact, right? Something which is going to work, also require, agreement between parties 3 years down the line, 4 years down the line, then you don't know how the relationship at that point of time would be, and you don't know how both parties will agree. So don't push some of these unresolved issues for later. Try to see if you can resolve if it's going to have a long term impact. If it's a short term impact and you can't agree on certain things, you say, okay, fine, maybe right now is not a good time. 2 months down the line, we may have a lot more clarity. That's fine. You are likely to sit across the table and resolve it. So there is some points you need to keep in mind when you're doing documentation, and then again, getting the ancillary documents in place and going to closing, right? So that's the typical life cycle we will look at it for starting a joint venture. Uh, I hope I covered a broad thing, Gowree, and if you think there are any things which you want us to go in detail, you can ask us later. Thanks. Over to
So
you.
that reminds me, Vaibhav, when you said that you have to go into detail. So it reminds me of when I started looking at joint ventures, some of the issues we had to look into the past, interpretation of the past joint ventures. This was probably early 2000s. This was a laptop or digital joint ventures. Those used to be, if I remember correctly, 10, 12 pages. That's it. And one of the most successful joint ventures, right? Post that we are over legislating and we are just going into hundreds of pages. So I wonder how those joint ventures functioned effectively, which were 10, 12 pages, and how, even today with 100 pages, the joint ventures, sometimes don't function, right? So ultimately, it sometimes also boils down to the point that you mentioned is the relationship between the parties and how, the culture of both the parties that have come together, how they fit in to continue as joint venture partners, right? Coming to the other points, I think on the business plan, I think one of the key takeaways for me when some of the joint venture disputes I saw was how the business plan has been articulated, because and how it has been updated from time to time. And that becomes a key. It doesn't sometimes form part of your joint venture agreement, but simply a to-do item. And in fact, in one of the joint venture disputes, the real thing that saved us was one particular sentence on top of the business plan as to what was the real intention of that business plan, right? So sometimes even those ancillary documents become very, very relevant if at all there is a dispute. And the point that you mentioned about 5 year, whether 5 years down the line, how it will be interpreted. So we have had situations where we had to actually look into the entire negotiated position, right? So how well have you maintained the negotiated position documentation? Of course, the document has to be read as a whole, only within the document, but some of the interpretations you can rely upon extraneous, sort of communication if at all certain things are not clear, right? From a contractual interpretation principles perspective. So all these things also definitely come in handy. Couple of points, from a for what we have also seen as an additional step in the joint venture is the audit of the Indian partner, because quite a few times from an FCPA and UK primary law perspective, we have seen extensive audit being undertaken not only of the relevant company but board members, shareholders, right up to the top, right? So sometimes that exercise also we have seen, as one of the steps involved in the joint venture, sort of process. Coming to Varsha, from a tax perspective, Vaibhav did mention about unincorporated joint ventures. So maybe you may want to spend a couple of minutes on an EOP aspect in that context. Also, he mentioned about term sheet. Now, what we have often seen at the term sheet stage, your articulation of the structure or the flow of funds, whether there will be a dividend payout or whether there will be money taken out of royalty or otherwise, is not still crystallized because parties are still doing their Excel sheet. at that point in time, one favorite line that sometimes get inserted that, parties will finalize the structure, tax efficient structure, right? Sometimes you do insert that kind of a line. So when you now have GAR and, sort of standing, in front of you, how careful should the parties be when exchanging these pre-documentation, documents like term sheet, email exchanges, because you do end up deciding your commercials basis, the tax positions, right? So can you just think about a couple of these items and any other at the structuring stage, the precautions to be taken?
Sure. Thank you, Gowree, for that question. And the very short answer to how careful parties need to be is very, very careful in today's day and age. As we all know, and we must have all heard in the business world that the world of tax is changing pretty much completely. Everything we know as concepts, everything we know as settled judicial precedent and positions are changing now. And the result of this is that a lot of presumptions that parties would have in undertaking certain types of businesses and transactions are now being brought into question. The focus the world over for any kind of structuring, any kind of transaction is documentation, 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 and it cannot be stressed enough. So yes, even term sheets and unsigned documents, even discussions over emails, etc., become very important in a situation where we are in a highly litigious tax environment, and the law itself is not stagnant anymore. It's changing as quickly as every few days. In the joint venture context, a lot of factors become very important to consider and evaluate at a very, very preliminary stage. So all the commercial points that Vaibhav mentioned earlier, each and every commercial step has a tax impact, and it's very important for the parties to consult their tax advisors, understand the consequences completely before they sign on to something and have a repercussion which comes as either a surprise or becomes a very, very heavy tax cost. Many times tax costs become heavy enough to actually become prohibitive, and can actually stop a party from wanting to engage further in the transaction. So especially in a joint venture context, when one party is a non-resident and another is a resident, it's very important to understand the tax treatment, because there's a large disparity in the way non-residents are taxed and residents are taxed in India. Of course, choice of entity becomes very important, as Vaibhav said, for incorporated entities. When we're considering companies and LLPs, there is a difference in the manner that they are taxed. LLPs are taxed in India at the level of the entity itself, whereas any distributions further are free from tax. Dividends from companies are taxed in India now. There used to be a dividend distribution tax, which has been done away with. Uh, and while that's good news largely, because the dividend distribution tax used to create a lot of issues for foreign parties getting foreign tax credit on that amount, it brings with it a new problem, which is the problem of establishing beneficial ownership to the dividend income. Because a lot of tax treaties with India require that the entity that is actually receiving the dividend is a beneficial owner of the dividend, and can only then avail of a lower tax rate under the tax treaty. While these are choice of entity issues in cases of incorporated entities, in case of unincorporated entities, the issues are somewhat broader because of, Gowree, what you mentioned, the AOP risks that are involved. AOP is an artificial juridical person under Indian tax laws. It's called an association of persons. And under Indian tax laws, when any parties come together for a common intent or purpose to share in certain profits, they are regarded as being one entity, one taxable entity, so to say. The problem with this characterization is that when you have one entity, like an AOP, the entire income of that AOP is taxable at the maximum marginal rate. Where one of those entities is a foreign company, that rate can be as high as 40%. So it's very important in case of unincorporated JVs to actually have documentation that very, very clearly, delineates that the parties do not intend to form a partnership, an association, a joint venture, etc., and very clearly divides up the roles and risks that the parties are intending to take. So while this is on the aspects that need to be considered to set up the JV, there are also aspects that need to be considered in terms of the exit options that are available for JVs. And these aspects need to be considered at very preliminary stages as well. So exits from incorporated entities like companies and LLPs draw a capital gains tax in India, and exits from unincorporated entities would generally see the form of termination of agreements, which can also have tax impacts depending on how that termination is undertaken. Um, Exits also bring about another issue, which is the choice of jurisdiction. A lot of times, because of certain ways in which tax treaties with India are worded or specific benefits under certain tax treaties, entities do prefer to use an intermediate jurisdiction to invest into India to be able to avail of those beneficial treaties. Um, Historically, it's been Mauritius, Singapore, these names that we have heard in the Indian context. This scenario is changing completely now. The Mauritius and Singapore treaties have been revised to do away with the capital gains tax benefit that was there under them. And even irrespective of the revision of those treaties, like you said, with the introduction of the general anti-avoidance rules, and now with the multilateral instrument that's been signed by a number of countries, and a global, treaty level anti-abuse provision that's been introduced, there is a lot of hesitation and a lot of questions that arise out of these, established jurisdiction, patterns that we had earlier. And in this context, it's very difficult now to actually just choose a jurisdiction simply because of a tax benefit. If tax authorities in India suspect that that is the case, they have the authority to actually take the transaction, recharacterize it to, completely do away with that jurisdiction and tax the entity as if it was characterized in another way. So again, even in this context, Gowree, the importance of documentation and capturing the key commercial rationale for doing the transaction in that particular way is very, very important. These communications, these documentation have to be robust, they have to be clear, and they have to be undertaken with the ultimate goal in mind, which in the world of tax is defending it before a tax officer. In a world where we don't know where the jurisprudence is going, everything is so new. It's very important, particularly now, for parties to have, very, very robust documentation in place. So yeah, Gowree, that's all I have to say on tax aspects regarding structuring of a JV. So yeah, over to you.
Thanks for that, Varsha. It was I know tax becomes somewhat complex sometimes. By the way, can you hear me well?
Yeah, you're quite clear.
So tax points do become complex sometimes, but what I've noticed is, whilst doing the entire, right from day one, the mindset should be that legal and tax and strategy together, right? You can't do one piece and then suddenly try to fit that into a hand in hand. And as you rightly said, especially when the world is becoming complex with GAR and all the time think what is a commercial rationale behind any step that probably we are undertaking and how we are able to justify that commercial rationale. I think that is going to be one takeaway. There is one question for you, Varsha, which probably you can answer on the chat on EOP. I don't think we need to take time here, but the point back to Vaibhav, essentially, especially on the board and shareholder points that you mentioned before, I want to come back to that, especially after the amendment to the Companies Act 2013, where board has been given, some specific or has been identified to have specific responsibilities. And when we say in a joint venture, typically this is my director, this is your director, but the director actually is the director of the company, right? So in those scheme of things, at the board level decision making, shareholder level decision making, how do you now think about it post 2013 era? In terms of from a documentation perspective, how do you look at this when you have to look at shareholders' decision or a board decision, and the interview?
Thank you, Gowree. So even before 2013, amendment came in, a director was always a director of a company, and he had a fiduciary duty to act in the interest of a company, right? Often, what we have seen is that when you have a joint venture agreement, right, they nominate, each partner nominates the directors. The directors, let's assume for ease of discussion, it's 50-50, and both have nominated equal number of directors. Then the joint venture partner expects that the director who is there will take care of their interest, right? Because they have nominated them, and because of that reason, they will actually work. Sometimes what the decision they need to do is may not be the interest of the company, but it may be interest in one of the joint venture partners. Um, in which case there is a classic conflict which comes up, because under the corporate law, directors has a fiduciary duty to act in the interest of the company. If tomorrow they take a decision which is actually interest of one of the joint venture partners but not in the interest of the company, that can be challenged, and there can be a issue from director perspective, because he is actually violating the responsibilities or the duty which the corporate law has put on him. So, we always tell our joint venture partners that, while it is important to have directors on the board and directors will do day-to-day decision making, you always have what you call negative or veto rights or negative rights, where certain decisions which you want to control should actually be done at the shareholder level rather than at the board level. You can actually put a mechanism where it can be done at both the places in a good way, but conceptually it should be a shareholder level decision. On board, right? You can always ensure that you have a requirement that if your director is not there, there won't be a valid board meeting. So it's a requirement. Typically what we see is both joint venture partner will have that requirement. So you can't really have a board meeting without the other joint venture partners director being present. So you can try to make sure that those kind of protections are there. So any decision taken by the board is covered. But if it is critical decision, then you create a veto right list, and that veto right list means that that particular decision cannot be taken by board until the shareholders have actually agreed in writing, right, of that board meeting. Either they've agreed in writing or they have agreed in shareholders meeting, right? So that is the way, basically, to overcome the issue of fiduciary duty on the director. In other words, do not rely on directors to take care of you or your issue. You need to take that matter in the hands of shareholders.
I think, interestingly, sometimes what I've seen, because I have had a chance to even see how the joint ventures get operated, right? One is the transaction, and thereafter the operation of the joint venture. And during that process, what we end up noticing that these rules, who is writing to whom, whether I'm writing in the capacity of a shareholder, am I writing in the capacity of a director, am I writing sort of just a business communication. I think that becomes absolutely important, and especially we have had a situation where we realize that parties are likely to get into joint venture dispute. That time onwards, even if there is a small sort of hiccup that comes up, parties have to be absolutely careful that how are they leaving the joint venture, right? Because one is to just have that 100-page document and put it in the cupboard and not look at it, versus to identify how do you live the joint venture and write kind of a code book and go by that code book. That becomes very important. So in this particular dispute I was referring to, we started actually identifying what should a person who was a director, right? He specifically said you're not going to write anything from a shareholder's point of view. You're simply going to say, this is the business plan of the company, this is required for the company, this is, this is the funding is required by the company from a business plan perspective, so whatever it was. So we said that the communication will be of a director's communication and not from, and from a company perspective and not from a shareholder perspective, right? So to bring that, sort of even during the process, how do you do the dual division, who is communicating as a shareholder even within a joint venture partner and who is communicating as a director. I think that becomes absolutely important when you get into a joint venture dispute. Till the joint venture is going well, no issues. But this, even if there is everything is going hunky dory, this particular thought process has to be kept in mind, in my view. And with that, I think coming to the issue about the dispute or a deadlock, what we have also seen that often you have situations where you need to take cognizance, especially in a 50-50 joint venture, or situations where you have affirmative rights, where it's a 59, 51-49 or a 75-26. Even in case of affirmative rights, there could be deadlock situations, right? And parties need to legislate as to if that were to happen, what are the consequences. So, Anusha, can you just give some examples of the possible solutions that we could have, which are contractually agreed? Of course, I can always go outside the contract and try to resolve, but contractually, what could be the main points to be kept in mind?
Sure, Gowree. As Vaibhav mentioned, it's absolutely critical to have clear documentation in place, which means that even the ugly sides of your JV, that is a dispute or a deadlock, need to be captured in clarity so that tomorrow both sides walk away in a somewhat happier position than a completely ugly dispute. So first, let's just try and understand what exactly is a deadlock. A deadlock, very, very simply put, is a conflict in the understanding of some critical issues with respect to the JV between the two JV partners. Typically, a deadlock can occur, for instance, when there is no midway point, there is no agreement in relation to the business plan of the joint venture, or if there are certain reserve matters which one JV partner is not willing to consent to, or there have been two or more consecutive board meetings and the board has not been able to pass a resolution. Similarly, at the shareholders level, there has been two or more shareholders meetings, and the shareholders have not been able to pass the resolution with the required majority. So, in all these situations, a deadlock will occur. Naturally, in your documentation, it is best to actually think of what type of a JV you are and what sort of deadlocks can occur, and have a very watertight provision, because you don't want a deadlock situation being triggered for something which is not critical or something very trivial and which does not affect your joint venture. So it's very essential to ensure that a watertight definition is built into to understand what is a deadlock. Now, once such a deadlock occurs, what we typically document in a joint venture agreement is a sort of a cool off period, or a 60 or a 90-day period where the senior members of both JV parties try to negotiate and mediate and try to resolve the deadlock. Now, in most situations, if this is not a very core or a very critical issue which completely goes to the crux of the JV, it will get resolved. However, if parties are still not able to resolve the deadlock within the 60 to 90-day period, then the deadlock exit mechanisms are triggered. And I'll just discuss three typical ones that we see in JV documentation. Before I go into this, one important aspect that people should realize is that deadlock is not a default situation. In a default, there is a party who has breached a term of the agreement or who has violated provisions of the contract. A deadlock can occur when there is absolutely no breach of the terms, no default by any party, but just very simply put, there is no meeting of minds of the two JV partners for something that is very critical to the JV. So having said that, let's look at what is one of the most common resolution mechanism that we see, which is a call or a put option. Very simply put, a call option is primarily an option given to to a buyer to purchase to one JV partner to have the right, but not necessarily the obligation, to require the other JV partner to sell their shares at a pre-agreed price or a pre-agreed formula. And put option is a right given to a party to put their shares or to request the other party, not request, to require the other party to purchase their shares at a pre-agreed price. Now, depending on what the type of a JV it is, a call or a put option can be put in. For instance, if it is like an 80-20 JV with the 20% shareholder not having the financial wherewithal to purchase the 80% shareholding, it would make no sense to have a call option, to have a put option given to the 80% shareholder in favor of the 20% shareholder, because they don't have the financial capabilities. So you have to keep in mind and ensure that both parties, or the party who's given this option, who has to buy the other party's shares, has the financial capabilities to do it. Secondly, a call or put option is also very useful when there is a minority JV partner involved, because it is easy for the majority partner to get them to exit. And a put option is also a form of a downward protection for a party. For instance, if someone has invested and finances are a key aspect and they don't want to lose too much money, and if the JV is not going as well as they expected, then they can put their shares and cut their losses and exit the JV. So depending on the dynamics of the parties and what each party is bringing to the table, party should carefully negotiate whether they should have a call or a put option. The other form of JV deadlock resolution mechanism we typically see is a Russian roulette. This is not as common as a call or put option, but it is seen in a lot of documents in India and abroad. This is a very simple mechanism where a notice is given by one of the JV partners to the other JV partners with a price at which it is willing to buy the second JV partner. Now, the receiving party may either accept this notice and accept to sell its shares at the price mentioned therein, or instead say, I will purchase your shares at the price that you have mentioned in the notice. Now, such a form of Russian roulette would make sense when there's a 50-50 JV partnership and where no party has any extra vested interest or any unique bringing in a unique aspect that it has brought into the JV, and both parties are nonchalant and not really worried about being bought out from the JV. So in such a situation, a simple Russian roulette would work. This will also work because a party would never quote a very low price, because they know that the other party can then reject their offer to buy and agree to buy them at that same very low price. So parties will also ensure that whatever price that they put out there is very reasonable and it is agreeable to all parties. The last form is called a Texas shootout. This is a sort of a variation of the Russian roulette. So what happens in this deadlock mechanism is that one party sends a notice with a price that it is willing to buy out the other party to the second with the price that it is willing to buy out the second party for. The second party can either accept that price, or if it rejects that price, it can send a counter notice with a higher price that it is willing to pay for the first party. Now, the first party may accept this counter price or reject it now and state that it wants to buy the second party. So in a situation where both JV partners want to buy each other out, a Texas shootout is triggered, which means primarily both parties put in a sealed confidential bid of what they are willing to pay to buy the other party out. Whoever has the higher bid will then have to buy out the other party at that higher bid price. So again, parties will be careful here to ensure that whatever they quote is not too high and that they cannot fulfill, and they won't quote something very low, because then they may be forced to exit out of a JV. So a lot of these deadlock resolution mechanisms come down to strategy and understanding what each party requires. One important aspect with respect to Indian JVs when it comes to these deadlock mechanisms is we need to understand the foreign exchange regulations when a foreign JV partner is involved. Now, under the Foreign Exchange Management Act and the non-debt rules, an optionality clause cannot have any assured price. There cannot be any assured return or exit for any foreign party. So which means that you cannot have a call or a put option stating that you will definitely buy the foreign party at 1x the investment amount or whatever. It can be a predetermined formula, but it cannot be an assured exit. So this, in a way, is it's difficult for a foreign party to ensure that their downside is properly protected. But the foreign exchange laws always are made in a way to protect the Indian party, and this is something the foreign party who's entering the JV should be careful of. And second aspect is that when shares are sold from a non-resident to a resident, the price per share cannot be more than the fair market value. And when shares are sold from a resident to a non-resident, the price cannot be less than the fair market value of the shares. So there is a floor and a cap on how the price of shares will be operational. So therefore, again, in things like Texas shootout and Russian roulette, the foreign party would be cannot obviously pledge its shares for, offer its shares for a higher price and fair market value. So again, parties must carefully negotiate and ensure that whatever price they put out there, valuation reports supporting that this is in compliance with the foreign exchange laws of India. So just finally, just covering why this is a deadlock aspect, just quickly covering what are the other exit mechanisms that are available to joint venture parties, which in a non-deadlock situation. So if there is a default of a party, parties can again have a call or put option in case of a default, or they can also go into arbitration. In non-default scenarios where parties just want to consensually terminate the joint venture, there are 2 or 3 options. One is your voluntary winding up. They can wind up the company and distribute the proceeds after everybody, all the creditors and the employees and all the proceeds as per IBC are paid off. Second is that there can be a sale to a third party. One of the JV partners, typically in a JV partner controls most of the company. They can sell the shareholding to a third party. And in case of a sale to a third party, we've also seen rights being built in to protect a minority JV partner in the form of a tag along right. So that because a minority JV partner may not want to be stuck in a JV with a person who they don't have any knowledge of or who their JV partner has sold their stake to. Similarly, to protect a majority shareholder, drag along right can be built in, which primarily means that if a 80% JV partner is exiting, they can drag along the 20% JV partner to also sell at the same price and ensure that there's a 100% exit. So depending on what, again, each JV partner brings to the table, these sort of clauses, whether a drag or a tag or a preemptive right in the form of a right of first offer or a right of first refusal, should be built into the JV agreement. And that all of this should be very clearly documented at the time of negotiations of the document itself, and not later when a dispute is actually has arisen between the parties. Over to you, G.
Thanks a lot, Anusha. For a minute, when you were explaining Russian media and all of that, I was wondering whether I'm actually a part of some gaming-related webinar or not. But that was very interesting. I think a couple of takeaways that you mentioned is, on the point about, especially in the context of the exchange control regulations that you mentioned. Sometimes we have also seen, considering this particular requirement of the pricing, restriction that we have, sometimes parties also negotiate that, I could appoint another Indian party, for example, as a nominee, and that nominee will buy you out, right? So basically, then this will be a local transaction, and then the pricing issues may not necessarily arise. Right? So we have seen those decisions as well as part of negotiation, especially considering the point that you mentioned. But I think you have articulated all the other aspects pretty well for the audience. I'm sure there will be some questions that may have come up for you, so you can just check the question and answer below. But I think with the time that we have in hand, we want to still cover a couple of items. So Vaibhav, there are oftentimes non-compete clauses that are heavily negotiated, right? And of course, the ancillary agreements that you mentioned, which are a part of the entire scheme of things. So I'm going to slightly change the question considering the way Anusha has explained the exit part. It also becomes important to unwind the ancillary documents as a part of termination process. So your thoughts on these specific points on the non-compete and unwinding ancillary documents as a part of exit. What are the precautions that one has to take in advance?
Yeah, thank you, Gowree. I hope you can hear me. Hello? Can you hear me?
Yes.
Okay. So, yeah, so let's take non-compete first, right? So non-compete in my mind is important, one during the term of the JV and maybe later post-termination of the JV, right? That both the places. And that this is a key aspect, right? That going back to what I was saying, what is the objective? Why both parties are coming together, right? Is it something which requires certain things exclusively from one party? If you require certain things exclusively from one party, then you will have a non-compete provision built in. You will have non-compete provision for that particular business which that joint venture is doing, right? Important aspect is that when you are doing a joint venture agreement, you may have certain business in mind, but by the time the things develop, by the time the joint venture progresses, the business may have changed or may have kind of added up. So when you plan your non-compete clauses, you need to make sure you plan it in a manner where it also covers something which a joint venture company may do even in the future, right? So how you define the business definition and how do you define the joint venture non-compete definition is very critical. Also, we need to make sure that there is a clarity that not just during the term of the joint venture you want that to be that the non-compete to apply, but also beyond the termination of a joint venture agreement, non-compete needs to apply. If that is a plan and that is the intention, then you need to clarify the geography, the period, and you want to make sure that you need to tie it up along with the termination clause, because when the termination of the joint venture happens, invariably there will be transfer by one shareholder to another shareholder. Now, when that transfer happens, the person who is transferring, the shareholder, is transferring shares of the company. Now, if you see our non-compete law under Contracts Act, right? The Contract Act typically says that non-compete is a non-enforceable clause unless there is a transfer of business with goodwill, right? The question is that when I'm transferring my portion of shares, right? Is it something which is transfer of business with goodwill, right? Again, it will depend on what is the percentage which is being transferred and whether that can be construed as transferring of business, and whether the goodwill rights are continuing to be given. So that definitely raises a question of whether I can enforce a non-compete simply because I am transferring shares to my joint venture partner. Now, having said that it is possible to do it. You still want to make sure that there is a clarity in situation where non-compete is important. Now coming to other aspect of non-compete, which is with respect other aspect of ancillary agreement.
Not only one of the foremost innovators and writers about technology, but
Just one second.
an equally interesting one.
So then ancillary agreements, right? So when you terminate ancillary agreements, you want to also have a complete understanding of what is the implication of that termination of ancillary agreement, specifically in case of let's say IP license, right, or technology transfer. Does the technology go back to that company? If it was a technology transfer, what if the joint venture had developed additional IP which is based on top of the IP which was given by one joint venture partner? What happens to that? So that also needs to be carefully identified and kept it, right? If there was a brand license given, right? Then there should be a time frame, because that brand was used by a joint venture party for a long period of time. There should be a continuity plan, right? Of how long the joint venture party company can actually continue using that brand before they need to stop it. So there needs to be a continuity aspect which needs to be kept in mind. I think I can go in and go on long, but considering the time, I think I'll stop now.
One aspect before I go to Varsha, we have to sort of discuss a couple of tax items and a couple of competition law items. But one important element sometimes parties from as a negotiation point keep till the end is the dispute governing law and dispute resolution clause. Then that's the first clause in my mind that needs to be negotiated to say, okay, what is the governing law of the contract? Because all your negotiations, the manner and especially the way you will negotiate your non-compete reps, warranties, etc., will be actually guided by the governing law, and that's one thing I believe should be discussed in advance so that you can sort of plan out the negotiation of the entire agreement accordingly. But since we were discussing about Varsha, you briefly touched upon earlier about the royalty and the dividend aspects. Could you spend a couple of minutes quickly to sort of explain the current position under the law when it comes to all these IP licensing? What are the tax treatments, especially in the cross-border transactions?
Sure, Gowree. So these ancillary agreements that we have in JV context, usually one party is contributing some form of technological know-how or providing some form of service to the JV entity at hand, and these are governed by intercompany agreements. So the first and the most important thing, especially in a cross-border context, is the applicability of transfer pricing to these payments. Um, these payments, when made between resident and resident, usually are not subject to transfer pricing requirements unless they fall under the specified domestic transactions. However, in the international context, it's very important to ensure that all these payments are at arm's length and are also supported by appropriate valuation, documentation, etc., to justify the arm's length nature of these payments. So that is again one of those scenarios where the treatment of a resident JV partner and a non-resident JV partner is different. Apart from the transfer pricing aspect, also there is withholding tax in India on a lot of source-based payments. The withholding tax in case of a payment made from a resident to a non-resident has to be undertaken by the resident in India, and there are a lot of compliances also attached with it, which the resident party as well needs to undertake. So if it's a payment being made from the JV entity to the non-resident JV partner, the JV entity will have to obtain the TAN and do the withholding and deposit it in time, give the certificate of deposit to the JV partner, etc. So there are all these things to consider. Particularly in a non-resident context where the country has a tax treaty with India, the TDS rates and the actual tax treatment becomes important to analyze under the treaty, and also under the beneficial ownership rules that we spoke about earlier very briefly. Because the beneficial ownership condition is something that is attached to a lot of source-based payments under treaties. So royalties, your fees for technical services, interests, dividends, etc. And where you have such a beneficial ownership condition attached, it's very important to be able to justify that you are actually indeed the beneficial owner of that income and are not merely a conduit for passing it on to another entity. Apart from the transfer pricing and withholding tax implications, there are also indirect tax implications under the GST regime. While this will depend completely on the way in which the transactions are structured, these need to also be kept in mind because they are an additional cost, and parties may need to register in India or at least factor in the cost where the tax is charged on a reverse charge basis, where the Indian entity has to make the payment of the tax. So these are a few of the tax considerations that need to be kept in mind in context of the ancillary agreements.
Sure. So I believe, often I've seen that these also become a part of your business plan, right? The tax cost and the manner in which it should be handled, and also part of your business plan in terms of, contingencies, etc., right? So these are the things also to be kept in mind, right, from day one as we discussed before. I know we are running short of time, but one very interesting aspect that we should touch upon before we wind up today is a competition law issue. So, Anusha, do you spend a few minutes quickly before we wind up on what are the key considerations to be kept in mind for the JV?
Sure. So just to give a brief background, the Competition Act and the merger control regulations came about in 2011, and Regulation 5 basically defines what is a combination and what are the various thresholds that need to be met. If those thresholds are met, then you need to apply for CCI approval. Since there are different levels, I won't go into it because we are running short of time. You all can just look at Regulation 5. Now, the interesting thing is that the word joint venture is not defined under the Companies Act, under the Competition Act or the merger control regulations. So there was always uncertainty on whether a newly formed joint venture, whether even if it triggers certain conditions of the combination, whether you would still need to apply for CCI approval. So in 2016, the Competition Commission came out with an FAQ stating that yes, a joint venture which meets certain thresholds will also need to apply. And let's look at one of the provisions of the Companies Act, which is your anti-circumvention provision, which is Section 5, subsection 9 of the Competition Act, which basically states that at any time when you're doing a series of transactions and when there is an asset which is being transferred, then the value and the turnover of the enterprise which is transferring the asset should also be taken into consideration while determining whether the Competition Act thresholds have been met. So for instance, if there is a 5,000 crore turnover company and it is just transferring a 50 crore asset to a joint venture, then as per a plain reading of this rule, the JV would have to go in for an approval. 5,000 crore parent company would also be taken into account while determining the threshold. However, in 2017, there was a clarification which came by way of a note. What the government basically said is that they clarified that it is not the entire asset and turnover, not the entire turnover of the company that needs to be taken into consideration, but only the asset which is being transferred. So in the example that I gave, since the asset is only 50 crores would be the threshold that would be taken into consideration and not 5,000 crores, which is of the entire company. So this in a way is good because new joint ventures which are set up, which don't meet the requirements of the threshold requirements of the CCI will not need to get approval. There is also a de minimis threshold, which is not only for joint ventures, but for any sort of merger or combination, which basically states that if if your turnover is less than 1,000 crores, or if the value of your company is less than 300 crores, then you are exempt from any CCI approvals. So if you have a JV which fulfills these criteria, then you don't need to go in. However, if you exceed this criteria, for instance, I think in February there was Mahindra and Ford entered into a JV where Mahindra picked up a stake in one of Ford's subsidiary, a 51% stake and the value of the company was 1,200 crores, and they had to go for CCI approval, and they had received the CCI approval in around 6 to 8 weeks. So depending on the value, you should definitely ensure that you go get the competition commission's approval if needed. Back to you.
Great. Thank you. Thank you, Gowree. We are at the end of the session. Great takeaways from today's conversation. I believe the strategy, complete understanding of strategy from both sides, the cultural, synergies between the parties, whether it's a short-term or a long-term JV, try to determine in advance, uh, try to legislate as much as possible, though I have sometimes difference of opinion there, but try to legislate as much as possible in all situations. Try to see the entire timing of, right, the consummation, all the regulatory approvals, FDI approvals, competition law approvals, what are those timings to be kept in mind before you sort of decide the timing of the launch of the JV. And of course, during the JV, what are the do's and don'ts? As Vaibhav said, director, shareholder, etc. What are the do's and don'ts at the commence, during the term of the JV? And of course, if at all things are not going well, what are the various options available for the parties to end that JV? And on that note, I will sort of end the conversation here. But Actually, we could have had almost 3 sessions covering each of these elements in much detail, and maybe some other time. But for now, we are taking your leave and wishing all of you a very happy weekend.